morning. I am Hanilibia Austria, class number 3, and I am going to about Chapter 2, Proof of Filiation, Article 172 of the Family Code. The filiation of legitimate children is established by any of the following: the record of birth appearing in the civil register or a final judgment, an admission of illegitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned, in the rules of court and special laws. In the absence of the foregoing evidence, the legitimate filiation shall be proved by 1. The open continuous possession of status of a legitimate child, or 2. Any other means allowed. So filiation may now be established through forensic deoxyribonucleic acid or DNA. Record of birth must be signed by the father to prove filiation. Otherwise, it is incompetent evidence to prove the filiation of the child to the father. Order of the court: the decision of the court to prove the filiation of the child to the father in order that he or she may prove the right to inherit. Authentic writing: the father of the child executed a will instituting such child as one of the heirs and recognized child. It may be public or private writing. Private writing must be handwritten by the father and signed by him, otherwise it is not admissible. The requisites are mandatory. Open and continuous possession of the status of an illegitimate child or any other means to prove filiation. For example, baptismal certificate, judicial admission, common reputation respecting the same pedigree, admission by silence and testimonies, form witnesses, and others kinds of proof under Rule 130 of the Rules of Court. Consolacion Lumahin, Dep Aparicio versus Hipolito Paragua, GR number L 29771. Facts: Trinidad Montilde, a young lass of Tubigan, Bohol, had a love affair with a priest, Reverend Father Felipe Lumain, and in the process she have conceived. When she was almost 4 months pregnant, in order to conceal her disgrace from the public, she decided to marry Anastasio Mamburao. Father Lumain solemnized their marriage on March 4, 1924. 192 days after the marriage, Trinidad gave birth to Consolacion Lumain. As shown by her birth certificate, her registered parents are Trinidad and Anastasio. On October 31, 1936, Father Lumain died, but he left a last will and testament wherein he acknowledged Consolacion and his daughter as his daughter and instituted her as the sole and universal heir of all his property rights and interests. Soon after reaching the age of majority, Consolacion filed an action in the Court of First Instance of Bohol against Hipolito Paragua for the recovery of certain parcels of land she claims to have inherited from her father, Lumain, and for damages. Issue: whether or not Consolacion Lumahin de Aparicio is entitled to inherit the property of the deceased father Felipe Lumain held. Consolacion, having been born after the 180 days following the celebration, shall be presumed the legitimate child of the spouses Trinidad and Anastasio. Moreover, the plaintiff's filiation of being a legitimate child is proven by the record of birth appearing in the civil registry. In the will of Father Lumain, she was acknowledged as his natural daughter and designated as his only heir. Article 214. In cases of death, absence, or unsuitability of the parents, substitute parental authority shall be exercised by the surviving grandparent. In case several survive, the one designated by the court, acting into account the same consideration mentioned in the preceding article, shall exercise the authority. So, the case here in Santos versus CA, the facts are: Luel Santos Jr. was born out of the spouses Luel Santos Sr. and Julia Bedia Santos. Since birth, he is under the care of his grandparents. His mother left for USA as a nurse, and the father alleged in a petition that he did not know her whereabouts. RTC awarded the custody to the maternal grandparents of the child and contended that they are in a better position to take care of the child. Issue: who should be awarded the custody of the child? It was held that the custody should be awarded to the father in the absence of or death of one parent, the joint parental authority shall be vested alone to the surviving parent. Only in the case of parent's death, absence, or insuitability may substitute the parental authority to the grandparents. Article 215. No descendants shall be compelled in a criminal case to testify against his parents and grandparents except when such testimony is indispensable in a crime against the descendant or by one parent against the other. Chapter 2. Substitute and Special Parental Authority. Article 216. In default of parents or a judicially appointed guardian, in the following person shall exercise the substitute parental authority over the child in the order indicated. 1. The surviving parent, as provided in Article 214. 2. The eldest brother or sister over 21 years of age unless unfit or disqualified. 3. The child's actual custodian over 21 years of age unless unfit or disqualified. Whenever the appointment or judicial guardian over the property of the child becomes necessary, the same orders of preference shall be observed. Article 366. A natural child, acknowledged by both of the parents, shall principally use the surname of the father. If recognized by only one of the parents, a natural child shall employ the surname of the recognizing parent. Article 367. Natural children by legal filiation shall principally employ the surname of the father. And Article 368, illegitimate children referred to in the Article 287 shall bear the name of the mother. End of my report. Thank you po for listening.